I would like to welcome you all to this new panel. Our forum today aims to showcase the leadership of Hong Kong across the many areas where Hong Kong has a competitive advantage. And one of those areas is exactly the use of Hong Kong as an arbitration place and also as a legal jurisdiction hub. So we are delighted to have with us a terrific panel. I will let Dimitris Seirinakis introduce our panelists. I'd like to thank Benjamin, of course, for being a great partner for this forum and for having every one of you with us today. So without any further delay, I will turn it over to Dimitri to take over. And thank you again.
Thank you, Nicholas. Welcome, everyone. I think before we kick off the panel, Benjamin has some introductory remarks for us, and then I'll take it over from him when he is done. Benjamin, over to you.
Yes, thank you, Nicholas. Thank you, Dimitris. It's great here today with this panel. At first, when Nicholas was telling me about this panel with all people from the legal profession, I said, no, I don't want to be on that panel. I will just do a remark. That's less pressure for me. Now, in our email exchanges earlier for this panel, Dimitris used this phrase that Hong Kong is a legal and arbitration powerhouse. I believe this is very true, and it hasn't changed. Although we have had a rough year or 2 years, ranging from the US and also Sino tension, trade tension, to the social unrest here in Hong Kong, and also COVID-19 this year. But Hong Kong is still kicking and alive. How well are we kicking and alive? This actually is something that I'll leave it to the panel to tell you, because they're all from different countries, and also including good portion actually living here in Hong Kong. But for me, actually here, I would like to say a few words on the arbitration first. I think we have done well in the past year on arbitration. If we look at it from 3 different levels, on international level, we have IMCO named us as one of the 4 arbitration venue. On a national level, we have the interim measure, which is now implemented. Actually, we also have this supplementary agreement signed earlier, a few days ago. And then on a city level, we have the Hong Kong Maritime Arbitration Group, which is now moved out from the HKIAC and become independent and much more efficient now. So I think we have quite a number of good news on the arbitration side. For the interim measure, I mentioned that we have this supplemental agreement signed on the 27th, 2 days ago. Now, this is very important as it expressly confirmed that the relevant courts may impose preservation or mandatory measures pursuant to an application before or after accepting the application for enforcement of an arbitral award. And it also allows parties to make a simultaneous application to the mainland and Hong Kong courts for enforcement of an arbitral award. So this is very good for us. And as you know, Hong Kong is the only place around the world which got this interim measure in place with mainland China. And also another good news is that we have this Greater Bay Area legal professional examination for the legal practitioners, including young solicitors and also barristers with 5 years of experience. After passing this examination and obtaining the lawyer's practice certificate for the Greater Bay Area, they are allowed to practice in the Greater Bay Area, the 9 cities within mainland China. So I think very quickly, I have mentioned about the achievements that Hong Kong has done for the past year, and more importantly, the opportunities lying ahead for the legal sector in the Greater Bay Area. So I think I have painted a broad enough and good enough backdrop for the panel. So without further ado, I will hand it over to Dimitri to start the panel. Thank you.
Thank you, Benjamin, for these brief introductory remarks. I'd like to start briefly by also thanking our hosts, Capital Link, the Hong Kong Maritime and Port Board, and InvestHK Hong Kong, of course, for offering us this platform today. As Benjamin already alluded, the aim of this panel, the fourth panel of the day, is to discuss the recent developments in the maritime legal sector in Hong Kong, and to assess and discuss Hong Kong's ability to continue to offer these unparalleled services that it has offered so far in the region and the world at large. In this aim, we are presented with a panel of immense depth and knowledge and actually distinguished service to the industry. So please allow me to welcome Arthur Bowring of the Hong Kong Maritime Arbitration Group, Rosita Lau of Ince & Co, Lianjun Lee of Reed Smith Richards Butler, Andrew Ridger Green of Stephenson Harwood, and Edward Liu of Hill Dickinson. For our viewers, you will note there's a Q&A button in your Zoom platform. Feel free to use that. Our aim is to allow time for questions towards the end of the panel discussion. As Benjamin mentioned, there have been a number of recent developments, and he also alluded to the fact that in exchanges between us, I refer to Hong Kong as a powerhouse. Rosita, if I may start with you, please. You have been a long-time servant of the maritime industry in Hong Kong and clients around the world. What is it in your view that makes Hong Kong such a popular and successful legal and arbitration venue?
I think we have a lot of good things, too many good things to say within too short a period of time. I just want to be concise. First of all, I think we have the hardware and software all here. Hardware-wise, of course, is because we have the very good legal system here. And even after the return of the sovereignty over Hong Kong back to China in 1997, we still continue to be run under the one country, two systems principle. That is, we still carry on with the capitalist life way. And we are ruled by the rule of law, and also we still follow the common law system. I think as everybody knows, I believe all the participants, all those who are watching us, understand that common law system is the most established legal system of the world, and also what the international shipping community always follow. And more importantly, because the law of Hong Kong are still modeled on English law. So English cases still have very, very big persuasive power when judges in Hong Kong are judge cases. Now, hardware-wise is this sort of thing, but then software-wise, basically, is the law itself. Other than English law, we still carry on. Although we have the new constitutional law, like the basic law, or the recently we have also some the new law governing the security, like the national security law. But all these will not affect the strength of Hong Kong as a really prominent legal center, in particular for industry like shipping, which is very international. And also we have independent judiciary, and all the judges are not civil servants. In other words, they will not and will not follow, say for instance, what the chief executive want them to rule cases. And in addition to that, we have the people here, which I think is the most important thing. That is the software-wise. We have the people here. I just want to call myself. I believe that I may be the only one among all the panelists today. I may be the only one who was born in Hong Kong, of Hong Kong origin, but also educated partly in Hong Kong, partly overseas. I was partly educated in England, but then I practice, as Dimitris you mentioned, thank you very much. I practice basically for clients over the world. So I think I'm well placed to say that one of the reasons for our successful being the international regional legal center is because it's the people here, it's the brain here. We got judges, arbitrators. We have Arthur here. We have lawyers like Lianjun, Edward, Andrew, and there's so many others. And we believe that we understand how our clients operate business. It's very important that we know the languages. We speak, write, understand, and can listen to English and Chinese, and many Chinese dialects here. And in Hong Kong, we have so many famous and long-established maritime law firms from England and America. And together, we can actually practice maritime law. We help the clients here. So no matter you're from Hong Kong or overseas or from mainland China, we can help you because we know how you think, we know how you operate. I think it's very important for clients to know that because they have the clients to understand how they operate and how they work. In addition to that, I think the important thing is we are very user-friendly. We have judges in the Maritime Court on rota 24 hours around the day, 7 days a week, and 365 days a year. I remember that the common law system is so important is because I believe that in East Asia, not to mention China, Hong Kong is the only place in East Asia which practice common law. The common law system is important because international-wide for shipping industry, common law system is the most popular system, and English law is the most widely applicable law. So you can see that we have hardware, software here. We know the people, we have the language skill, we have the brain here, and then we have so much experience of acting for people coming from mainland China, trying to go out under the One Belt One Road initiative, and recently, 3 years ago, the Great Bay Area initiative. So I think we are absolutely well placed to continue to be an international legal center and also the dispute resolution center. You mentioned.
Thank you, Rosita.
Yeah.
Sorry, I was just going to ask you to wrap up because you've packed a lot in 5 minutes there, and there's certainly a lot of what you've just mentioned we will be discussing later on as well. One, of course, of the points that you alluded to and Benjamin mentioned in his opening remarks is that Hong Kong is continuing to promote itself and kind of reinforce itself as a dispute resolution center. And in that regard, it's joined by the central government in Beijing. I'd like to turn to Edward because he was one of the early success stories in using one of the tools that the Hong Kong and mainland China government implemented, and that was the very snappily named mutual arrangement of the enforcement of arbitration awards. Edward, yes, I understand there have been some recent developments which are of great interest both to us as practitioners, but obviously also to the end users of the services that Hong Kong offers. Would you like to brief us on what's been happening recently?
Yes, many thanks, Dimitris. And also it's it's my pleasure to be here as a panel member with so many other prestigious lawyers in Hong Kong in shipping and commercial area for the dispute resolution. Indeed, as Dimitris, you mentioned, and also Benjamin briefly mentioned about the recent development. I think as an arbitration lawyer, we all can share the agreement that in the past few years, we are so excited to see many things happening, the good things happening to Hong Kong, especially, for example, last year, Hong Kong and the mainland signed the arrangement on the interim measures in aid of arbitration proceedings in these two jurisdictions, which I understand that the other panel member will elaborate it later. And then, as also you mentioned, the Department of Justice, together with the Supreme People's Court of China, signed another arrangement, which is also significant to Hong Kong arbitration. That is supplemental arrangement concerning mutual enforcement of arbitral awards between these two jurisdictions. that was signed last Friday, 27th November. Actually, when you read the supplemental arrangement, basically, that especially issued by the Supreme People's Court, there's another supplemental document to this supplemental arrangement regarding the notable cases relating to the mutual enforcement of the arbitral awards in these two jurisdictions, i.e., there are five cases referring to the enforcement of the Hong Kong arbitral awards by the Chinese court, the mainland court, and then another 5 cases for the Hong Kong courts to enforce the mainland awards. And because I'm a member of the advisory committee of the promotion of arbitration, so I had a privilege to discuss the details of the supplemental arrangement, and also I contributed a few cases which has now been released from the Hong Kong side. So that is indeed very, very exciting, I think, to all the arbitration lawyers, not only for the shipping, but also for all general arbitration lawyers in the city. Basically, as we all know, that there was an arrangement signed between these two jurisdictions in 1999, 20 years ago. It has been the arrangement, basically, we all agree that has successfully provided a simple and effective mechanism in both jurisdictions on the enforcement of arbitral award. It also, I think, fairly to say, fosters the legal and judicial cooperation in civil and commercial matters between mainland China and Hong Kong. And therefore, upon review of the implementation of that original arrangement, both sides agree that it's necessary to make some appropriate amendments so as to update the arrangement to the current needs. The supplemental arrangement actually is very short and very simple. There are basically 4 issues. First, expressly including the term recognition when referring to the enforcement of arbitral awards, because if you see the original arrangement only refers to enforcement rather than the recognition, which is a bit bizarre because like the New York Convention, it refers to recognition and enforcement. And secondly, it has added an express provision to clarify that a party may apply for preservation measures before and after the court's acceptance of an application to enforce an arbitral award, which I think is vital important as well, because as I said, that we now have the arrangement on the interim measures in aid of arbitration proceedings. That is for before and during the arbitral proceedings. And now with this additional provision, we understand that during the enforcement stage, we can also apply for the asset preservation. Thirdly is the definition of the scope of arbitral awards, because previously only the listed arbitration institutions from mainland China can have the enforcement of their awards in Hong Kong, but now it only sees the seats of arbitration instead of the institution, the arbitration institutions. Last but not least, and also the most importantly, it removes the current restriction of the arrangement to allow parties to make simultaneous application to both the courts of the mainland and Hong Kong for enforcement of an arbitral award. That is critically important because of last year, there was a case in Hong Kong that the successful party of the arbitration tried to apply for enforcement of that award in mainland, but that was lasted more than 6 years and failed. And then when the successful party tried to enforce it in Hong Kong, it was already barred. So that is a disaster actually for a successful party. And because of this new terms under the supplemental arrangement now, the parties can be rest assured that they can apply for the enforcement of the award in both jurisdictions, as long as, of course, that the sums that you're applying for the course are not exceeding the awarded sums in the award. So so with this
Edward,
full
can I
provision,
just
we now have a perfect mechanism. Yeah, that's all. Conclude my.
Sorry, I was going to interrupt you there because obviously this is an extremely important update, but and possibly the most important update recently. But it is actually for the better. Only one of a whole suite of developments aimed at boosting Hong Kong's competitiveness. And I'd like to turn to Andrew now. And Andrew, you're the head of the arbitration practice of a major shipping law firm. You are indeed an arbitrator as well. Some of these developments Benjamin spoke to during his introductory remarks, but would you like to spend some time to sort of alert everyone to these other developments, including perhaps the BIMCO dispute resolution clause that Benjamin mentioned in the beginning?
Yeah, thanks very much, Dimitris. I guess one of the things that has concerned me and the international community that are my clients over the last number of years is whether Hong Kong can possibly remain a good arbitration venue, particularly when there's strong competition from other venues in the region and obviously traditional venues like New York and London. And I'm extremely thankful to Rosita and Edward for laying out what we have here in Hong Kong. But in some senses, that those steps that have been taken don't always allay the fears of our colleagues overseas, because they don't necessarily see things from a close perspective. I was talking to some clients in Japan probably about a year ago, and they were beginning to raise rather important questions as to whether Hong Kong could remain a robust and strong and independent venue for dispute resolution, given the then political situation, given that a number of the agreements that they were looking to enter into were extremely long-term arrangements, and arrangements that go to sort of the core of trading and transport arrangements. And a number of my clients were thinking about possibly choosing other venues. And so it is, it's really great from our perspective as Hong Kong practitioners to see that organizations like BIMCO continue to have faith in the system here in Hong Kong, and it's excellent that the Law and Arbitration Clause 2020 has included Hong Kong as a venue. And in terms of our infrastructure, I would say that Hong Kong continues to try and perform to the international norms. The arbitration ordinance is no longer new, but it does follow the UN model law, and therefore follows what is expected of international arbitration centres. In addition to that, it brings in some of the features that we're quite familiar with in English arbitration, and so gives us the possibility of appeal, which most model law countries don't do. Now, under Hong Kong, the general Hong Kong law, you can't just appeal an arbitration award. You have to have agreed to incorporate the appeal terms. But one of the excellent things that BIMCO has done, and as we all know, within the shipping world, arbitration clauses tend to be tacked into an agreement at the very last minute. Nobody really thinks about them very much. And we'd end up with rather hodgepodge agreements. The good thing about the BIMCO Law and Arbitration Clause is it weaves in the Hong Kong Maritime Arbitrators Group's terms and conditions, which also opts into the second schedule of the arbitration ordinance, which is obviously boring law stuff. But what that means from a user's perspective is that it includes the right to challenge an arbitration award on a point of law or for serious irregularity, which is not normally available under the arbitration ordinance. So from a maritime perspective, this a great vote of confidence from the international maritime community, and in combination with Hong Kong MAG, an excellent compromise between the international standards of the UNCITRAL model law and the possibility and benefits of being able to appeal and challenge arbitration awards.
Thank you. Thank you very much, Andrew. I was going to suggest, I mean, the great, big, huge white elephant in the room that hasn't been mentioned yet in this panel, of course, is COVID-19 and its impact on all of us and all our business and also our personal and professional lives. I was intending to ask Arthur, as someone who has pretty much fought every challenge thrown at the Hong Kong maritime industry in the past few decades. Now, in his role as president of the Hong Kong Maritime Arbitration Group, he's thrown this challenge as well. And with that background, Arthur, I just wanted to kind of pick your brain to try and understand what can Hong Kong do? Indeed, what is it doing to remain relevant in a world where almost everything right now, including this forum, obviously, is done remotely, is done virtually?
Thank you very much, Dimitris, and good afternoon, everybody. Good morning, wherever you are. Yes, what are we doing to remain viable? What are we doing to remain Hong Kong and to offer? Well, Hong Kong, as Rosita said, Rosita, Edward, Andrew, you've all made very, very good points about what Hong Kong offers. We actually have quite a special position in the world, in that we are part of China. We're the only common law system within China. We can hold arbitrations, of course, in English and Chinese and other languages, but being so close to China gives us unparalleled access into China. Now, China is still the big mover of goods. It is still the major commodity trader. And so to have that access into China, it is incredibly important. I think later on, we'll probably discuss the Greater Bay Area developments and One Belt, One Road. But certainly, we still have access into China, being here in Hong Kong, that probably nowhere else has. Other people have tried, other centers have tried to encourage access. They tried to be there in China and to, if you like, market their strengths. But the strengths we have in Hong Kong are really quite special. We've already spoken about the interim measures. What we also have, which is not talked about very much, is the, and this is another long title, and I'll blame the Department of Justice for this, the pilot scheme on facilitation for persons participating in arbitral proceedings in Hong Kong. This is quite a special arrangement because, of course, for anywhere where people go and work, they have to have some kind of employment visa. This new arrangement, it allows people participating in arbitral proceedings in Hong Kong to come here with a letter of proof that actually allows them to come into Hong Kong on a visitor visa and take part in arbitral proceedings. Now, of course, at the moment with COVID-19, you're absolutely right, Dimitris, probably nobody is traveling very much. It's all done virtually. But this does give Hong Kong a major step forward. It gives us a strength that I think it's probably quite hard to replicate. We do have fantastic connections here in Hong Kong. I don't know if anybody has been into the Legal Hub, into the EBRAM office, where they have several connections, very high-speed connections into the different routes coming through Hong Kong, which gives them unparalleled virtual access for virtual hearings. So we are, in fact, very well set up in Hong Kong to offer commercial resolution of disputes, whether it's by arbitration or mediation. We have the law firms here, we have the counsel here, but we also have a very energetic community. So, I mean, I do think that one of the reasons, as Andrew said, that we've been recognized in the BIMCO clause is because of what we can offer, if you like, the brand of Hong Kong Mag. It is actually a very exciting time. And this year, especially, I think we're seeing quite a rise in the number of appointments that Hong Kong Mag arbitrators have been given. So it is working. We do have areas here which are quite different to other parts of the world. We have a system which, as Edward has pointed out, with mainland China, that can be amended very rapidly if we find areas that need to be improved. And as I say, unparalleled access. And that really is a major strength for Hong Kong.
Thank you. Thank you very much, Arthur, for that glimpse in not only our present reality, but what is potentially increasingly going to be the future of both Hong Kong and arbitration in general. I'd like to kind of latch on into something that you mentioned in passing, and that was, of course, the BRI and the Greater Bay Area initiatives. And Lianjun, of course, not only are you a member of the Hong Kong Maritime Arbitration Group, supporting Arthur and his team in his efforts, but you're also a panel arbitrator in CMAC and CTAC, and you still maintain a thriving private practice. Wearing any one of those hats, or all of them, perhaps, I don't know. I mean, have you yet seen any BRI or GBA-related disputes being litigated or arbitrated in Hong Kong? And against that background, perhaps with that in mind, would you like to spend maybe a couple of minutes to tell our viewers and remind them of kind of Hong Kong's role in these two initiatives, and also recent developments which kind of Rosita touched upon earlier during the panel discussion?
Thank you, Dimitris. Good morning or good afternoon to all of you who are attending this seminar. I would also like to take this opportunity to thank Benjamin Wong of Investment Hong Kong and Nicholas and Annie for their invitation. And for the BRI, for those who are not familiar, this is it's a Chinese policy to develop along 138 countries who have signed the treaty with China. And so that's the BRI. The arbitration, we have been dealing a few, but not too many. The reason is, I can guess, because the big projects are just started. And there are disputes relating to the power plant or the terminal operations between the investors and the users, so I can see. However, the volume of the trade, we can see will be increased in due course. And naturally, maritime trade or dispute will arise. Similarly, GBA in Greater Bay Area. And similarly, you have goods movement and people's move, and we expect the disputes will arrive. Now, Hong Kong, like other speakers like Rosita, Arthur, Andrew, and Edward said, we are well positioned in both initiatives. If you look at the Chinese, it's called 13 5-year plan. It specifically say Hong Kong will be an international arbitration center, and China will promote such role. And similarly, GBA. There's no other countries, no other cities in those plans. Someone may attended a seminar or conference last year Jack Ma said, the only country with 1.4 billion is China. They perform the national plans. So hopefully we can use the position. As I said, Hong Kong is the only jurisdiction in China with such big economic import or export with common law jurisdictions. So I can see, because the national plan has positioned Hong Kong as such position. And like BIMCO, very pleased to have BIMCO in the chosen Hong Kong as the place. Rosita and I, Benjamin, together with Frank Chen or other shipowner associations, we visited BIMCO last year, and we lobby this. The reason is simple. Hong Kong is the best placed to resolve the disputes, in particular the users, traders with China. I think it's good opportunity. Hong Kong, we can play more in the BRI and the GBA, and in order to show the strengths of Hong Kong legal professionals, I think we should work together more. Let's say we need promote us to the Chinese government, Hong Kong government, and the business circles, like BIMCO. If they have BRI or GBA standard contracts, Hong Kong should be the first one. We should promote this. I think Edward and Rosita, we have been trying hard to get the Chinese government or the business circles to choose Hong Kong, and that's a natural choice. The other things I'm doing is, or with Rosita and other people, we are trying to, Hong Kong's position has been, positioned in the national plan as a dispute resolution center. Why not we have Greater Bay arbitration institution or court in Hong Kong so we can serve? And last Saturday, I attended a seminar, and I understand the Chinese university has done a survey. 70% of the Hong Kong invested company in Guangdong area chosen Hong Kong law as a governing law in the contract. That's really good for the Hong Kong lawyers. Even they choose the Chinese court. I mean, it's good. You have a dispute, and 70% is a large sum. So we should promote those associations to use Hong Kong as a basis of dispute resolution, or at least Hong Kong law will apply. So
Lianjun,
I think we do. Yeah.
I was going to interrupt you very quickly there, just because this raises a very interesting point, which I would like to open to the rest of the panel.
Yeah.
And it's this. A lot of these initiatives are jointly, if you will, between Hong Kong and mainland China.
Yeah.
And of course, these are, as you mentioned, initiatives that are very beneficial to Hong Kong, show to the rest of the world that China intends to maintain a prominent role for Hong Kong in her development and her kind of global expansion. But the question I have, and perhaps I would start with Andrew on this, is, are these initiatives a double-edged sword for Hong Kong, in the sense that, is there a risk that Hong Kong will be rightly seen as the gateway to China, which it has always been, but wrongly seen as of smaller relevance to the rest of the region? To kind of use a not particularly apt term, is Hong Kong risking becoming a one-trick pony in the sense of just dealing with kind of China disputes? Andrew, if we could hear from you first.
Yeah, that's a really good question and a very challenging question, Tim. Thank you very much for it. I'm not sure I'm very happy to answer it. I would, I must say, when I first heard about the government's GBA plan, I was a bit sort of taken aback and thinking, oh my gosh, this is really the end for Hong Kong, or the beginning of the end. and then I read the plan a little bit more closely, and I looked at obviously not in Chinese, and I apologize that I can't read the Chinese, but I was quite pleased that the way that the role of Hong Kong is still preserved within the GBA plan to be a dispute resolution center, not just for China-facing disputes, but for international disputes as well. And I think that the institutions that are present in Hong Kong are very keen, and obviously China is important to Hong Kong because we are part of China, right? But at the same time, we are an international city, and notwithstanding recent troubles that the city has seen, and fortunately restoration to peace, I think, we still have one of the most international judiciaries in the world. I mean, if you look at the senior courts here, and you compare it to the senior courts in England or the US, which are seen as sort of bastions of common law liberalism, Hong Kong has a much more representative judiciary than anywhere else in the world. And that's the sort of backbone that backs up an even more diverse and international arbitrators list at the Hong Kong International Arbitration Center, and a specialist list in the Hong Kong Maritime Arbitrators Group. So I would say there is obviously a potential that it could run down the route of being a one-trick pony, but I think that that certainly the institutions and the intention is that it's not going to be that, and it will remain an international city for relevance.
Thank you, Andrew.
No worries.
Sorry, I do.
No.
You mentioned institutions, and I didn't mean to interrupt you. But speaking of institutions, Arthur, do you share the cautious optimism that Andrew?
I'd probably go overboard a little bit more, Dimitris.
Well, you're more than welcome to. Please
I wouldn't be cautious at all. But in some ways, you've posed a very good question. What is it that would bring people to use Hong Kong maritime dispute resolution from around the world? Of course, our links to China are important. Is that a one-trick pony? Is that just one thing? We have, what you need to have is a very successful dispute resolution center. You have to have the support of the courts. We have fantastic support of the courts. You have to have a strong legal profession, which we certainly have here in Hong Kong. You need to have Hong Kong arbitrators and mediators. It's not, you don't make yourself into a dispute resolution center by having people from other jurisdictions sitting on your panel. You have to create your homegrown experience and expertise. And we certainly have that. We have a lot of strengths that really, when you look at the virtual world of arbitration, which I think in some ways we might be heading towards, whether we like it or not, I still think that we can attract people into using Hong Kong because of the strengths that we have. The strengths that we have, I'm afraid, do surpass strengths that other competing jurisdictions might have. And if you want more information on that, I can refer you to the website of Hong Kong Mag, where we lay some of these out in some detail. But I really think that in the virtual world of arbitration, or when people are choosing a venue, Hong Kong should really be pretty much at the top of the list.
It's not for me to say as a moderator, but I would tend to agree. Rosita, Lianjun mentioned that you and Edward, and of course a lot of us know that between the three of you, you are tireless campaigners in kind of promoting Hong Kong, not just vis-a-vis China, but just generally as a standalone jurisdiction. Where do you stand on the optimism scale? Are you throwing caution out the window as Arthur is doing? Or are you more cautiously optimistic as Andrew is?
I am absolutely optimistic about the development of Hong Kong, being not only the regional, but also international dispute resolution center. And I have listened carefully to what Arthur and Andrew had said, replying to your question. My thoughts are quite different. My think is that China is now the second largest economy of the world. So the need for arbitrations and legal services, dispute resolution services, can only be growing. It cannot be reducing or diminishing. So the whole thing is that they need the service. And we are here. And we are not only serving people of the mainland China, but because for arbitration, there must be an agreement and there will be dispute arising from an agreement. So if the agreement is with, say, for instance, some Western people, then by being the arbitration place or system of arbitration, we are actually not only helping China, but also helping the other party to the agreement. No matter they are from Europe, Africa, Southeast Asia, other East Asian countries, whatever, you name it. So in that way, basically is, as Arthur mentioned, China is, of course, an important point here, but we are also basically advancing international arbitration in that way. So absolutely, I am very optimistic about that. We're here, we will advance further, and we will excel.
Thank you, Rosita. Actually, in the process of your remarks, you answered the final question, and actually the closing question that I have for you as panelists. We have about just under 5 minutes to go. So I wanted to invite each and every one of you in 1 minute or less to deliver your own personal message to those who have been using Hong Kong, or indeed considering now Hong Kong as a venue for dispute resolution in the region, especially in relation to competing jurisdictions that Arthur mentioned. So what is your message to those people who are, a lot of them are our clients or our members as a P&I club, and what is your verdict on the health of Hong Kong as a legal hub in Asia? Rosita, you inadvertently already answered the question. So Edward, I'll give you 1 minute before I go on to Lianjun and Arthur and Andrew.
Yeah, many thanks, Dimitris. Indeed, I share all the comments by the other panel members on your question, which is very good question, actually. And I sometimes also have this kind of questions from my clients, especially for those foreign clients. And also, I think most of us have seen recently, like Financial Times and also some other international newspapers commented on the independence of judiciary here, and also make the question mark regarding whether Hong Kong can still maintain as a neutral place. Well, we are not going to that in detail, but I think we all agree, especially for our shipping arbitration, maritime arbitration, parties can choose their own arbitrators. And all the arbitrators, actually, as long as you choose those renowned or respectful arbitrators in Hong Kong or worldwide to arbitrate your case, you can still you enjoy the same neutrality and impartiality of all the arbitrators. For example, if you have the arbitration in London or or elsewhere. So that's the message I'd like to.
Let me stop you there, Andrew, because it's a good juncture, because you spoke of impartiality, which is very important in what we do. Arthur, closing remarks from you, and then I'll go to Lianjun.
Very, very quickly. Take a look at Hong Kong. Take a look at our website, Hong Kong Maritime Arbitration Group. Low and predictable costs, efficient and expeditious. We have a lot of experience here in Hong Kong, and I believe the disputes that we're resolving are well accepted by the parties. Thank you.
Thank you, Arthur. Lianjun, 30 seconds from you, and finally from Andrew.
Okay, I was in Qingdao last week, so I told the people there, say, choose Hong Kong as a dispute resolution center. We have fantastic legal system. We have good arbitrator, lawyers, P&I clubs, everything. you can find for shipping. Thank you.
Thank you, Lianjun. Andrew?
Yeah, I guess I would just very quickly finally say is that growth comes through pain. I think Hong Kong has been through a few months, a year or so of examining itself and just taking a long, hard look at itself. And through that, it's going to come out stronger, more resilient, and more able to do that. And we as a firm are showing a belief in this by growing our international arbitration practice. And today we were joined by Dr. Fan Yang, who's a well-known arbitrator and practitioner as a partner in our Hong Kong office. So growth in Hong Kong, I think.
Thank you, Andrew. Well, there's nothing left for me but to thank you all for your time and for your contribution today. And I will leave it to Nicholas now. Thank you very much, everyone.
All I want to say is thank you very much. Dimitri, you did a great job. And of course, every one of you had tremendous insight to contribute. Tremendous thanks to all of you. Thank you.
Thank you.
Thank you, everyone.
Bye-bye.
Thank you.
Bye-bye.
Bye-bye.
Thanks.
Bye.
Bye.
Bye.